In a historic moment inside the U.S. Supreme Court, facing the 9 justices, Denzel Washington stood confidently at the lectern dressed in a tailored Navy suit. Just moments earlier, Chief Justice John Roberts had issued a stunning challenge. "Mr. Washington, I find it difficult to believe that someone from your background fully understands the constitutional implications of your position." The courtroom froze. Law clerks glanced at each other, attorneys sat up straight, and reporters scribbled furiously. With his storied Harvard background, Roberts sought to expose a celebrity's legal inadequacy. But Washington, who had quietly earned a JD from Howard University while filming major movies, was ready. He was arguing in Henderson v. Department of Justice, a case concerning the government's seizure of a Philadelphia community center without charging the owners. Most had dismissed Washington's amicus brief as celebrity activism until they read it. His 40-page submission proposed a groundbreaking originalist argument on the Fifth Amendment's takings clause, challenging decades of civil forfeiture precedent. When Washington was granted 10 minutes for oral argument, a rare honor, the legal world scoffed. But when he began, "Mr. Chief Justice, and may it please the court," his calm, authoritative tone signaled something different. Then came Roberts's early interruption. Washington didn't flinch. "Chief Justice Roberts, I believe my argument is consistent with the Fifth Amendment's original meaning, as Justice Thomas outlined in Timms v. Indiana." He produced historical documents, flipping directly to pages, and cited the Palmyra, 1827, arguing it was a maritime outlier, not justification for today's broad land-based seizures. "I've traced all 27 civil forfeiture cases between 1789 and 1850. Every one involved customs, piracy, or maritime issues. None allowed property seizures like we see in Henderson." Gasps filled the courtroom. Justice Alito pressed him on more recent precedent like Bennis v. Michigan. "Justice Alito, I believe Bennis was wrongly decided," he replied, citing dissents by Justices Thomas and Ginsburg and newer rulings like Austin and Timms that reaffirm forfeiture as quasi-criminal and thus constitutionally limited. Justice Kavanaugh asked if he sought to abolish civil forfeiture. "Not at all," Washington said. "Just restore it to its original boundaries, admiralty, customs, or cases lacking personal jurisdiction." Roberts pressed again, "How can we trust your obscure state court citations as mainstream?" Washington responded smoothly, "Far from outliers, they reflect a consistent national pattern across early American jurisprudence." Even Justice Kagan was impressed. "Did you work with legal historians?" "No, Justice Kagan. I did the research myself during law school and after." When Justice Sotomayor asked how his theory applied to Henderson, Washington listed 3 constitutional failures: the tenuous link to a crime, lack of owner knowledge, and failure of the seizure to serve a public use. The seizure transfers property to general government funds, that's not public use. It's revenue generation. The justices extended his time, an extraordinary move. Chief Justice Roberts asked about the practical impact on existing cases. Washington had the numbers ready. 87% of current forfeitures, those with criminal convictions or unclaimed property, remain unaffected. Only the 13% targeting innocent owners would be constrained. Justice Barrett brought up a novel point from his brief, the connection between due process and takings. Washington cited James Madison's 1788 letter to Jefferson, noting that Madison explicitly warned against the double violence of seizures without process or public purpose. Even Justice Thomas spoke, asking whether Bennis should be overturned. "No need to overturn it," Washington said. Bennis involved direct criminal use. Henderson does not. The court can distinguish without reversing precedent. Finally, Roberts asked what test Washington proposed. 3 parts, he replied: a substantial connection between property and crime, clear and convincing proof the owner knew and consented, and the forfeiture must address specific harm, not generate revenue. Roberts visibly leaned in, then closed. "Thank you, Mr. Washington. Your argument has been exceptionally informative." As Washington returned to his seat, the opposing attorney looked shaken. Legal observers sensed history unfolding. The oral argument transcript went viral. Legal blogs, law professors, and social media exploded with praise. Hashtags like #LegalScholarDenzel and #WashingtonTeachesTheChief trended. Reports revealed Washington had earned his JD with highest honors at Howard, funded scholarships anonymously, and studied constitutional law extensively. 6 weeks later, the Supreme Court ruled 7-2 in favor of the petitioners, adopting Washington's three-part test. Roberts authored the majority opinion, quoting Washington 4 times and acknowledging his research. Justice Thomas called for deeper reform in his concurrence. Justice Sotomayor cited Washington's data on community impact. In a striking statement, Roberts wrote, "This case reminds us that legal wisdom can come from unexpected sources." The court benefited greatly from the advocacy and historical insight provided by all who participated. Washington soon launched the Washington Justice Initiative, supporting communities affected by civil forfeiture. He lectured at top law schools and appeared with Roberts at a Georgetown law forum. There, Roberts admitted, "Mr. Washington taught me a lesson: never mistake celebrity for lack of capability." Washington responded, "The law rewards preparation. Arguments should be judged by merit, not identity." If this story inspired you, don't forget to like, share, and subscribe for more stories where preparation meets opportunity.